Hello everyone, welcome to Legal Darshan. In this video, we are going to discuss a landmark judgment that marked that is also marked as one of the judgments, one of the keynote judgments in the transgender jurisprudence in India. It is the judgment of National Legal Services Authority versus Union of India, that is NALSA versus Union of India, 2014 Supreme Court judgment. All right, so this case finds number 32 in the list of leading cases for AOR exam 2025 as given by the Supreme Court. So this is case number 32, NALSA versus Union of India for people who are preparing for AOR exam 2025. So now let's go into the judgment. This judgment is, of course, I think anyone right now in the legal domain is not untouched by the facts and by the judgment of this particular case. So this case is a civil writ petition filed before the Supreme Court under Article 32 of the Constitution of India. And in this case, the court is deciding how transgenders should be equated with all other persons, how transgenders are same to all other persons who are sharing the binaries of gender. Now, transgender people, the court in this case is also defining the word transgender. It is going into the literal meaning of the word transgender. So the court in this case is saying that transgender means the word trans and gender. It is combinedly meaning that somebody who is beyond gender, who is mentally or who is psychologically being construing himself as beyond gender, the person does not identify either with females or either with males. It is they are beyond gender. They do not adhere to the binaries of the gender. So now in this case, the court is interpreting few constitutional articles. The court is looking at Article 42, court is looking at Article 15, court is looking at Article 16, 19, and 21. So now here, court is using the word, court is denoting that in Article 14, 15, 16, 19, and 21, the words that have been used are person and citizen. Okay, so now the connotation here is person is not describing any gender, right? It is not saying a male or a female, it is saying person. So the main accountability, the main point of consideration to be taken into account, that laws are being made for all the persons irrespective of their gender. So person here, that every person is equal before the law and every person has the right to live with dignity, is person specific. It doesn't have to conform to any gender specifics for a person to claim those rights, claim Article 14 or Article 21. Now in this case, Supreme Court is holding that transgenders are belonging to a distinct socio cultural group, and because they do not identify either as a male or as a female, their identity is beyond gender. So we need to include them as a third gender apart from the binary of a male and female, so that we can ensure their personal autonomy and we can ensure that they have the right to self determine themselves. They have the right to express themselves that they are beyond gender, they are not in the binary of male or female gender, and that right is guaranteed to them under the right of expression. The right of self determination is guaranteed to them under the right of under the right of expression, freedom of expression, that is contained in Article 19 of the Constitution of India. Now in this case, Supreme Court is also looking into the language of Article 21, saying that the Article 21 conforms to basic human right of a person. And the Supreme Court is saying that when we are using the word person, it is not coming with a gender specific qualification. It is inherent. It is an inherent right for all the people who are born in the territory of India, that they should not be deprived of the life and liberty. So on Article 15 and Article 16, we do have a clause that there shall be no discrimination on the ground of sex. Therefore, even if I do not want to identify myself as a biological male or a biological female, I will not be biased because I am not sticking to the binary. So the Supreme Court herein is officially its verdict in NALSA versus Union of India is recognizing transgenders as third gender in the realm of constitutional law, or in the realm of transgender jurisprudence or gender jurisprudence, let's say, in India. Okay, so it upholds the value of privacy, self identity, autonomy, and personal integrity of the members of transgender community, upholding their rights under Article 19(1)(a), which is the freedom of expression, and Article 21, which is the right to dignity. Now, court here is looking at many international instruments, many international laws, many foreign laws, where the laws have been made for identifying a third gender, for identifying transgenders as a third gender. So, Supreme Court here is looking at by psychological test, which has been used in Universal Declaration of Human Rights. It has been said that the test to be applied to understand how the gender has been taking shape is not that of a biological test, but rather it should be psychological test, right? Now there are multiple problems suffered by transgender community. So there was a movie starring Sushmita Sen also. If you have seen the movie, you will find that how much transgenders have been suffering throughout the history. Now even the NALSA versus Union of India case, the movie is inspired by this case only. So there is the whole history where transgenders are, when the transgender was sick or when the transgender was killed, the hospital authorities do not give their bodies, and they do not identify their bodies as either male or female. Their bodies were left out in open, etc., etc. So these were the atrocities being committed on the transgender community. They were facing discrimination in various areas. Now these areas could be the employment areas or the health area and education area. So in this case, Supreme Court here is directing center to first recognize third transgenders as third gender, and that it was held. Now, when we look at this case, there is the very it's a very interesting and very thought-provoking paragraph that I came across is on the human rights. So the human rights here, this Supreme Court is saying that human rights are the rights that belong to every person. They are not given to me by any authority. They are not given to me by any state. These are the rights that are there on the basis that I was born as a person. Okay, so in this paragraph, the Supreme Court is emphasizing that it is not that when you legislate human rights into a law, they become human rights. They are human rights even before you are legislating. So the government sitting in power, or the sovereign sitting in power, is just procedurally giving me those rights. It is not that if they do not give me those rights, it doesn't exist. So human rights exist irrespective of any specifics, irrespective of what is the relationship between the grantor of right and the holder of right. Okay, it does not exist just because legal system is recognizing it. It exists just because a person is born. These are rights, are the inherent rights. Because a person is born, he is born with those rights. So Supreme Court is taking into account these facts, these obligations, that human rights have to be given to everyone. And here, when we are recognizing transgenders as third gender, we are facilitating for them, we are making available for them the human rights protection that they deserve, which was not given to them earlier. So even in medico, even in educational field, even in employment field, we do often uh, tend to have a bias. We do discriminate. That's a general norm, because that is how bias has been perpetrated in all of us. So this is the judgment. This is the judgment opening horizons for transgenders, opening gates for gender jurisprudence in the realm of transgender justice. And here in this case, if you look at the last few pages of the judgment, the Supreme Court, this is page number, the whole judgment is 120 through 123 pages. If you look at the page 121 of the judgment, from 121 to 123, Supreme Court is here directing the central government to first recognize transgender as a third gender apart from the binaries of the gender, that is male or a female. Then Second direction here is that transgenders do have a right to self identify themselves as their freedom of expression contained in article 19(1)(a). Then the court is directing center and state governments to take some step forward in the form of policy making, in the form of law making, and also help them in securing places in educational seat by providing some kind of reservation of. Now, when we talk of Indian context, India is a pluralist state. Intersectionality plays out in Indian context a lot. So there might be a situation that a person is belonging to a gender minority as well as a person is belonging to backward classes. So a person who is belonging to gender minority, let's say third gender, and the same person is also belonging to socially and educationally backward class or scheduled caste or backward class, then in those cases the discrimination gets even higher. So here the court is also taking note of that intersectionality, taking note of that issue that often arises in Indian jurisprudence, and telling center and is directing center and state to take measures so that these people are not discriminated. There can be made some measures for providing reservation to them in educational institutions or in employment. And they also there are medical directions that some medical situations, some HIV surveillance centers, etc., are to be operated separately for transgender communities. So center and state should address the problem faced by transgenders community, for example social pressure, depression, suicidal tendencies, etc. Now these are the guidelines providing separate hospitals and social welfare schemes, whatever state and center could possibly do. These are contained in the verdict of the Supreme Court in NALSA versus Union of India. After NALSA versus Union of India comes Navtej Singh Johar, which is decriminalizing homosexuality also. So this judgment, and then we are now moving to Suprio versus Union of India also, in which we are talking of same-sex marriage. The talk has come in the limelight. The talk is in the process. Of course, the rights are not yet granted because I think the Indian, because not I think, but it's in the judgment that Indian framework, the institution of marriage is not ready to accept the same-sex marriage as of now. But maybe few years later, this could be reality. Maybe few years later, we could again, somebody again files a petition before the Supreme Court of India. The question gets into reconsideration, and someday soon we will be allowing same-sex marriages as well. So NALSA marks as one of the first and keynote effort in the realm of gender jurisprudence pertaining to transgender rights specifically. Now we do have protection of transgenders right of 2019. We do have judgments like Navtej, which are furthering the gender justice. So we will be coming back with more such judgments. Navtej is also in the course. Navtej is also a judgment listed in the leading case of AOR. We will be having a discussion on it soon as well. Still then, stay tuned, keep watching. Thank you for being here. If you have any doubts, queries, feedbacks to give, you may write down to us in the comment box below. Thank you, everyone. Have a great day.